with the complainant. There's to be no contact with any minor. There's to be Chapter 62 registration. Court is going to sentence you to 45 years. Court will give you credit for any time served. All right, court is calling 2022 CR 7283, State of Texas versus Christopher Brent Davis. I have parties announced for the record for the state. For the defense.
For Mr. Davis.
Suzanne Kramer, also for Mr. Davis.
All right, Mr. Davis, you entered a plea on May 7th of no contest. The court found there was sufficient evidence to find you guilty. The court deferred finding of guilt. You're coming open to the court. Have both parties had a chance to review the report from probation?
Yes, Judge.
Yes, Judge.
Any objections, state?
No, Your Honor.
Defense?
I have a couple of corrections, Judge.
Yes.
Regarding his discharge from the Navy, it was stated in there that it was less than honorable. I think his actual discharge was a general under, what's it called? Under honorable.
Okay.
General under honorable, not less than.
Okay.
And at the very end where he states a few things he wanted you to know, he referred to something that happened to him at age 5, but a subsequent conversation with his mother that was determined to have happened when he was at age 2.
Okay. All right, any witnesses?
Not from the state, Your Honor. We just have argument.
Just Mr. Davis, Judge.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do have a couple other witnesses. Can we take them first, Judge?
Sure.
Thank you. I'm sorry.
All right, call your
Let's
first
call
witness.
Edith Davis.
All right, so raise your right hand for me. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Christopher Brent Davis.
All right, defense.
All right, Christopher, what is it that, other than what you already stated in the PSI, what is it that you would like the judge to know before she decides what your sentence ought to be?
Your Honor, there is no explanation. There's no rhyme or reason. Nothing would be able to be justified as far as what my actions did. There's every day that I live with regret because it's not only one person I hurt several people, including my own children, my own biological children. The only thing I can ask is for forgiveness from them, and I will accept whatever consequence that you seem as punishable, Your Honor.
All right.
And Judge, this is the part where I do, like I tell my wife, if I tell you something from here on out and that you can accept it 2 ways, one to make you mad and one to make you not mad, I mean the one that makes you not mad. Okay. So, question that we have is what's appropriate punishment for this type of case for
All
Mr.
right,
Davis?
I'm sorry, just 1 second. State, you don't have any questions, do you? All right. All right, thank you for giving your testimony. And so the range of punishment for this offense is 5 to 99 years or life.
That's correct, Judge.
So state, what are you requesting?
Do you want my request and my argument or just my request?
Your request.
You're asking for life, Your Honor.
All right. So they're asking for life. Defense, what are you going to be asking for?
Judge, we're asking for 20.
All right. So now, state, I understand why you're asking for life. Defense, I understand why you're asking for 20. So, one, I'm not going to sentence him to life. I've taken in consideration his testimony. I've taken in consideration the testimony from both his parents. And I want the parents to know, at some point in time in life, your actions are not the cause of your child's actions. Because how old are you?
38.
All right, so he's 38. At some point in our lives, when we're making our decisions, no matter what happened in our past that was horrible for us, or maybe our parents made a mistake in how they raised us, at some point, your actions are your own. All right, so I'm not going to sentence you to life, but I'm not sentencing him to 20. It's an egregious offense.
And if I may offer some perspective on that, Judge, that's what I
Yes.
intend to do. So we agree it's egregious offense. He agrees it's an egregious offense. It's something that went on for about 6 or 8 months from what we can tell from stipulated evidence. And yet the same day that we were pending, that we actually entered our plea, There was another person pending who's had a death of a child, injury to a child causing death. And the very next day, this same prosecutor's office, same prosecutor
I'm gonna object to this line
offered
of,
them 18 years.
All right, okay, so here's the thing. Defense attorneys, you all know that sometimes people can be at the Bear County Jail or at the prison. Sometimes there are people at the prison for murder, they get 5 years. Somebody else at the prison for murder, they get 30 years. Every case is different, and there's a reason why people are given certain times. And there are reasons why sometimes this court follows a plea, sometimes that I do not follow the plea. Now, what I'm telling everybody, the state has asked for life. State can ask for whatever they want. I've already told the state, I'm not giving him life. So the argument about what they did in other cases, that's not an appropriate argument. We're here for this. Now, if somebody wants to make an argument that the same fact scenarios, as we would call it in law school, that the case is on all fours, if there's another case that's on all fours with this case, where the state gave somebody 12 years or 10 years, then we need some explanation, because maybe things are not being done fairly. So if you can present a case to the court that's on all fours with this case where the state made an offer of something less than life, I think it's relevant. I'll hear it, because maybe something else is happening in the office.
Well, Judge, and I would offer you something on that. I think it's on all fours. I don't know whether it's on all fingers and toes, but there was a case in the 227th where the fellow was charged with continuous sex abuse of a child, same as Mr. Davis. He was allowed to plead to aggravated sexual assault of a child, same as Mr. Davis, but he was given 12 years.
All right, so
For a 4-year-old child.
So let me ask you this. Was that a case where you had a defendant who's alleged to have pretended to be a juvenile online and then tricked his stepdaughter into allowing him to engage in sexual activities with her by pretending if she didn't, the new friend that the defendant had created, life would be in danger?
Of course, Judge, I cannot offer you that, but they just, for selective prosecution purposes and sentencing purposes, substantial similarity, I think, is what they look for. And in this case, the same charge, same reduction, a 4-year-old instead of a 14-year-old, and this fellow gets 12 years and the state wants life. I know you said you're not giving that to them, but this guy gets 12 years in a different court, and Mr. Davis is looking at whatever that you choose to give him. So
Okay.
that's the only reason I'm offering that, Judge.
Right.
And again, back to I'm not trying to make you mad. I
No,
don't want to visit my sins on my client.
No. Here's the thing. One, I don't get mad. I believe that everybody should be allowed their argument. I've been a defense attorney before. People should be allowed their argument. I've been a prosecutor before. People should be allowed their argument. I don't get mad. And what I can tell everybody, when you're in jury trial, if this were a jury trial, guess what? Defense counsel's state's closing arguments, that's not evidence. Evidence is the steps that I have. Evidence is whatever testimony I receive. Closing arguments that counsel do on both sides, that's spin. And hopefully the arguments they're making is in some form or fashion connected to the case that was just heard. All right, is there anything else?
No, Judge, I would just like to highlight, there is one other statement from Christopher in the pre-investigation report at the very last page. It states that he was the subject of a grooming himself when he was around 12 years old by a 39-year-old. We've discussed this, and again, Judge, he's not of the opinion that it's any excuse for what happened, and he doesn't even really know if it lent any any substance or predisposition for him to have done this, but it's just offered for the court for contextual purposes.
All right. So I want to let you know that I heard all of the arguments. I internalized everything. And these are very difficult cases. Anytime someone comes open to the court, it's very difficult. And let me just tell you why it's difficult. This is the type of case where everybody will say automatically it's a life case, right? But I go on facts. I go on what I read. I go on everything. I go upon experience I've had in dealing with specific cases. Because otherwise, if every case were a life case, then guess what? We don't even need to have a punishment hearing. It's just, this is what you did. We prove it, you get life automatically. So I look at everything. What you've done, of course, is something very bad. And people are going to be impacted for years to come. Right. So sometimes when I consider what to sentence somebody to, I think about their age. I think about protecting of the public. And there are many things that I have to consider. Like, for example, is somebody going to allow you to be around children again? That's something I have to consider. Like, what age will you be where people will see you and they will not say, oh, that's a good catch. Let him babysit a child. Those are all things that I have to consider because part of my job is protecting the public. And I also have to consider evidence that's presented. I consider the stipulations that you stipulated to. So this is what the court is going to do. Court is finding you guilty. There's to be no contact with the complainant. There's to be no contact with any minor. There's to be Chapter 62 registration. Court is going to sentence you to 45 years. Court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Your Honor.
All right, we can go off the record. Here's the thing. I want to let you know, just a second. I want to let you know that I appreciate the fact that you entered a plea to this, you entered a plea to it early, that when you came before the court, you didn't try to be wishy-washy on whether you did it or not. You are a person who truly took full responsibility for what you did. And I appreciate that you did that. All right, so can you mute us, please? Person here for victim impact?
Here.
All right, you may proceed. And I'm going to stop your video. Excuse me?
Proceed
Yes.
with.
Yes, you can put the camera for him.
Yeah, Nova, you can talk, sweetie.
All right, you may proceed.
Do I start reading?
Yes.
Okay. Even after all you've done, after all of the activities you did, and all the messed up things you did to our quote unquote family, I was able to fill myself with remorse, empathy, and sympathy for you. Now, don't twist it because I still hate your guts and wish you the rest of your life in prison. Also, don't be expecting forgiveness out of me. You might be able to convince other people, but you won't get it from me. You ruined a lot, but don't go raising your ego because you thought you ruined my entire life. You've only ruined things in it. You got away with it, or you've also improved my life. You got me away from you and Ashley. You brutally taught me how not to be so naive. You got the rest of my family away from you and Ashley and into a safer place. But most importantly, you found a way to wind yourself in prison. Here's a small list of all the things you've done to me, starting with the bad. You've made me relapse many times, gave me PTSD. You gave me a sleeping problem, suicidal thoughts, plus 4 different attempts, depression, anxiety, paranoia and trust issues, problems with talking about my feelings, nightmares constantly, fear of using any bathroom, gender questioning, panic attacks, caffeine addiction, slight smoking addictions, not being able to make friends easy due to trust issues, and problems with family members. Here's the list of good things you've done in my life. You put me into a position where I was being put with people who actually care for me enough to take Wyatt and I as their own children. That's it.
All right, thank you. Is there anyone else? All right, Ms. Davis?
Yes, Judge.
All right, you may proceed
So I'm not sure where to start or the things to say to you, but this is where I'm gonna start. Almost 16 years ago, when we got married, you said you would never hurt me or my daughter, who was only a couple months old at the time, or any kids in the future that we would have together. And I believed you. As our marriage went on, you ended up breaking that promise. You made me believe that I was crazy, and to the point to where I had to see doctors, therapists, and I didn't have friends anymore. I tried to help you be a better person, and it made you mad. I had no real warning about who you were. I'm glad I finally realized it with the help of some friends that I did make, and I made it out 7 years later. I made it out before things got so much worse than what they already were. Separated, divorced, went to court for our kids. You made people believe that I was doing things to our kids, and I wasn't. You played mental games with me and would verbally abuse me as well. After everything that you put me through, all the tears and the 7 years, you had everybody still believing that I was doing all of this. But eventually, you were caught because you did it. Sorry. I've been angry, yelled, screamed, cried over everything, and I blame myself for it, for not being able to protect our kids. You're not half the person I thought you were. But after all these years, I realize that your actions say more about your character than they do about me. I hope that life gives you everything that you deserve and you live peacefully with your choices that you've made, because our children and I won't be losing sleep over you anymore. You are where you belong. I feel you not only need for me to apologize for things that you did to me, but to the rest of my family and to these kids. And I hope that you pray hard for that and that one day they can forgive you. But I also want to sit here and say thank you in a roundabout way, Chris, for everything that you've put me through, but because you've not only made me a stronger woman, but you've made me a stronger mother when it comes to protection of our kids. The kids have decided that they wanted to say something to you. Our daughter states that, to me, you were never really my father, only because you treated me like I was nothing, for always lying and never listening when I told you the truth, for robbing me of my childhood and making me have to grow up too
I'm gonna
quickly.
object to this.
All right, excuse me. I'm so sorry. The defense has raised an objection. I'm going to sustain that objection. Thank you so
Okay.
much for coming in to give your statements.
Thank you.
All right, thank you. All right, thank you. Court is calling 2022 CR 6397, State of Texas versus Lane Fuente. I have parties announced for the record for the state.
Jason Garahan, Your Honor.
Defense.
Jeffrey Martinez.
And are you Selene Fuente?
Yes, ma'am.
Did you review the document entitled motion to revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Selene Fuente who was placed in community supervision in 2022 CR 6397 for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on September 26, 2022 for a term of 8 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violated condition number 2 on or about the 5th day of January 2023 in Bear County, Texas. Defendant Selene Chelsea Fuente did then and there legally use a controlled substance, namely methamphetamine, violation of condition number 2.
How do you plead to that, true or not true?
Your Honor will waive the remaining violated conditions.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true and sentence you up to 8 years in the prison and up to a $1,500 fine?
Yes, Judge, I understand.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes.
All right, court will find violation of condition number 2 true. Is there a proposed agreement?
Yes, Your Honor. And it is to deny the motion, continue the individual on her probation, and to have an alternate men to order evaluation for felony drug court. If that is not satisfied, or rather, if she doesn't qualify, order SATF or SATA.
Do you want to raise your right hand, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Celine Monte.
All right, why are you not doing well on probation?
I was involved with the wrong person and I was just making a whole bunch of mistakes that I do not plan on making in the future, ma'am, and I do want to better myself.
Mistakes, choices.
No, no.
There were choices.
Yes, they were my choices.
All
My,
right, so you're not making mistakes, you're making choices. Why are you making bad choices?
I have no excuse for them, Your Honor, but I do plan and doing good, better choices. I want to do better, Judge, and I need help, and I'm working out. I would like to do anything I can to help work on myself. I'm willing to do the rehab. I'm willing to do anything to just better myself, not just for myself, but for my kids and my family.
All right, so there's been a previous referral to felony drug court. I cannot read the handwriting of the judge who wrote this.
Sean looked into that too.
Judge, she was, she met the criteria, but she had a pending case in the county court, which, that's why they denied her. So she needs to intensive outpatient treatment.
All right, and the county court case, has that been taken care of?
So look at that, Judge. Sorry. Did not check.
Do you have any open cases?
No, ma'am, I have no cases right now pending or anything. I
So
haven't
the county court case, has that been taken care of?
I believe so, yes.
All right, we're gonna look it up and see.
Good. It looks like she doesn't have any case, except for her FTR.
Hoping you will do well. I don't know if you'll do well. Your track record, it appears that maybe you're not gonna do well. So I'm gonna give you a choice. Here's your choice. I can send you to 3 years in the prison, or either I can continue you, but you're not gonna be released from custody unless you're in felony drug court or you're going to safety.
I pick what, either one of those?
No, what's gonna end up happening, I'll refer you to felony drug court.
Yes, ma'am.
If felony drug court is full, or if they do not accept you, then you're going to safety.
Okay, yes, ma'am.
So
Thank
is
you.
that what you're asking for?
Yes, please. I would like to do the program, one of those programs, yes.
All right. So I'll deny the motion, alternate conditions to include, referral to felony drug court. If not accepted, then safety. Defendant is to remain in custody until transfer to safety or felony drug court. Do you have any children?
Yes, ma'am, I have 3.
What are their ages?
A 13-year-old, an 8-year-old, and a 3-year-old.
And who do they live with?
Right now they're staying with my grandmother.
All right, your grandmother?
Yes. And my girls are staying with my grandmother and my son is staying with, his family.
All right, is Child Protective Services involved?
No, ma'am. They're not in my custody.
I'm sorry?
They're not with me.
No, but did you?
Oh, they were at one point, yes, ma'am. Yes, they were.
So we're gonna do CPS compliance. If applicable. Were your parental rights terminated or anything?
With my son, yes, while I was incarcerated, yes, ma'am.
Okay, so what were you incarcerated for previously?
I was incarcerated for a robbery charge.
So we'll do CPS compliance. There's gonna be proof of employment,
Yes, ma'am.
45 days upon release. There should be no employment as a home health care provider or with minors. There should be no unsupervised contact with minors until further notice. There should be 200 hours of community service restitution. I'm gonna order parenting classes. Once those are completed, the community service hours will be deemed satisfied.
Yes, sir.
There's to be regular reporting by Zoom or in person. There's gonna be the UA hotline upon release. And field visits one time per month upon release for 4 months. And 120 sober meetings in 120 days. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
No, thank you, I appreciate it.
All right, you're welcome. We can go off the record. So here's the thing. The previous judge just ordered for you to be on probation in community service hours and referred to felony drug court. So I'm adding what should have been added, or what I think not should have been added, I shouldn't say that, but what I think should be added.
Yes, ma'am.
So just in case, if you didn't know you were supposed to report bravery once a month. That's why I added it, so you'll know, because I didn't see it written on the docket sheet. But I know that your rights have been terminated to one of your children.
Mhm.
So that means that the rights haven't been terminated to the other two. You still have a chance to get your life together, perhaps be in their life.
Yes,
You
ma'am.
understand?
Yes, ma'am.
But do not, this is my advice to you, do not go out there having more children or getting involved in a relationship until you get your life together.
Yes, ma'am.
And once you get to your life together and see clearly, guess what? You will attract good people. All right?
Yes, ma'am. Thank you.
You're welcome. If you have a question, be sure to ask probation. If you feel as though they're not addressing it, you can always come back to court, okay?
Okay.
And if you graduate from felony drug court, I'll be at your graduation.
Thank
All right, good luck.
You judge.
Welcome. All right, Mr. Bell, before we go on the record, and of course, we'll put it on the record as well. Mr. Munoz was just appointed to represent you today because your attorney, you've had no contact with your attorney since you did the plea. I understand that sometimes people want to do things quickly and get over with their case and be done. But it may be in your best interest if you want. And if Mr. Munoz is available, I could bring you back on the 3rd, would just be Monday, so he can have some time to prepare an argument to you, other than, I'm sure you're throwing yourself on the mercy of the court.
Yes, ma'am. I just wanted to do it today.
All right, I want you to internalize what I'm saying.
Mm.
Let me put it this way. If there's some sort of an emergency situation, somebody has a bullet wound, there's a doctor, there's not a hospital for miles around. Maybe you're like, oh yeah, doctor, we don't need to do x-rays because I won't be able to make it to the hospital in time. This is where it looks like the gunshot wound is, so I'll just do surgery on the street. This is a situation where, one, you could be going to prison. And according to the plea bargain agreement that was entered, it is punishment is to be assessed at 6 years in the prison. The state is opposed to your application for preferred or deferred adjudication. It would probably be in your best interest to at least give this attorney some time to look things over. At the end of the day, guess what? If I were to send you to prison, you're still going to be at the county. If I were to give you probation, you're still going to be at the jail. You're not going to be released today. So it would probably be in your best interest to at least give your attorney some time to look over things. Do you understand? So, how old are you? 21. Yeah. I'm going to give you a chance to look over things.
Yes, Your Honor.
All right. So, is June 3rd enough time for you, or would you like some more time to perhaps gather?
I can just briefly check my schedule for that date, Your Honor. I just want to make sure I'm not overbooked on that Monday where it would have to delay the court proceedings.
Oh, no. And counsel, if June 3rd is not enough time for you, because I want you to have enough time to adequately represent Mr. Bell.
Of course, Your Honor, yes. Yes, Judge, I can do June 3rd or June 4th. Preferably that Tuesday, because I know tomorrow's Friday.
That way I can take some of the weekend Monday to look over. I don't know if the court's gonna be.
All right, well, I'll tell you what, if you want to do the third, we can do it on the third. If you want to do it on the fourth, if you want to do it on the sixth, whatever is enough time for you, you just let the court know, because I know you've just been appointed
Yes, sir.
and he's entitled to at least 10 days.
Yes.
So if you want to do it the week of June 3rd, we can. If you want to do it the week of June 10th,
Yes, Your Honor.
it's completely up to you.
Yes, Your Honor, and I did discuss this at length with my clients that, you know, I was well, technically afforded the 10 days. He did offer me some good information. I got a good working basis from. I just need to check out some things and review the offense report a little bit more. But yes, Judge, if we could do June 4th, I'll be ready and available that date.
All right. So if you want, I'll put it for June 4th, or if you want, I'll put it for June 6th. And if you want it to be recalled for June 4th, you can always come in on the 3rd and we can do it.
Yes, Your Honor.
So do you want me to just put it for the 4th, or you want me to put it for the 6th?
If you can put it for the 4th, Judge.
All right.
Tuesday. Yeah.
So we'll put it for June 4th.
Yes.
All
Your Honor.
right.
Sounds good.
All right. And what's up with the eye thing? Have you told your attorney about that?
Yes, this one.
All right. Is there any issues that I need to call the jail or anything?
He said that he got into a scuffle there. He didn't go into too much depth, but you can elaborate if you wish for the judge.
Right. Do you want me to call over to the jail?
No, no,
You sure?
yes, ma'am.
All right. Because if there are some issues at the jail or you feel threatened at the jail, just let the court know. I'll do what I can do.
Appreciate that, Your Honor.
All right. All right. Because I'm a firm believer when people go to jail, if they have time to do, they should be able to do their time in peace.
Yes, Your Honor. Yes.
All right, so we're going to bring you back on June 4th, and I'll give your attorney some time to see what arguments he wishes to make to the court, okay?
Yes, ma'am.
All right, thank you.
Thank you, Your Honor. Maybe.
You're welcome. Oh, could you give this back to Jason?
Of course. Yes, Judge.
Thank you.
Yes.
Thank you, Renee, so much. I appreciate it.
Yes, no problem, Judge. Happy to help.
All right.
No problem. Have a good day.
All right, and so Almanza, if you can come forward. All right, so were you able to get in touch with your attorney?
They said they were gonna call you.
No, that's not the way it works. So this is what I'm going to do. Their motion to withdraw hasn't been heard. I'm going to give you a reset. Are you employed?
No, not anymore.
All right, so I'm going to give you a reset for June 10th. If they're not here on that day, guess what? They're going to be your attorney. Okay, once you sign the reset form, you're excused.
Okay.
All right, thank you. All right, and I think is the last person we have, Angela Pettis. Do you have any other files that are over there?
Just Joshua.
Okay, could I see that file too? All right, thank you. All right, so I think we're done for today. Are we not? Are we done? Oh, now we can learn Odyssey. All right, so And do we have anything on the docket for tomorrow? I don't think we do.
I didn't even see the document for the day. I saw the. Yeah, because like yesterday I printed out some stuff from the recall docket.
Mhm.
I was like, and then I just was like, well, wait a minute, nobody sent it, sometimes if she forgets to send us the actual docket,
Mhm.
which we can get from our clerk. But so I didn't think about it. I was like, I should have printed out all that paperwork, so.
Oh, wow. Well, I think we'll be able, I want to say they asked us to clear our docket, so I think we'll be able to spend all day tomorrow learning Odyssey.
Well, I just
It's a voyage.
don't have a lot of.
Court is calling 2024 CR 0254, State of Texas versus Michael Anthony Perez. Could I have parties announced for the record for the state?
Daniel Escobar, State of Texas.
Defense?
Freeman Martinez.
Are you Mr. Perez?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
Do Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we're proceeding on count 1 intox manslaughter and count 4 aggravated assault with deadly weapon, and we're waiving count 2 and count.
All right, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Judge.
All right, off the record. So state and defense, if y'all will write here that the intoxication manslaughter is count 1, and then just do a comma, count 2, aggravated assault with a deadly weapon. So,
Yes, Judge.
Okay.
Sorry about that.
oh, no problem. So did you understand in count 1, you're charged with intoxication manslaughter, and count 4, you're charged with aggravated assault with a deadly weapon? Those are second-degree felonies. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine in each count. Did you understand?
Yes, Judge.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Judge.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Judge.
Did you understand by entering this plea, you were giving up those rights?
Yes, Judge.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Judge.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Judge.
Has anyone promised you anything other than the plea?
No, Judge.
Are you satisfied with the way you've been represented?
Yes, Judge.
Are you a U.S. citizen?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Off the record for a moment. This is attached to the court's file.
Was it a CD here?
Yes.
It should be.
Yes, Judge, that should have been in the stipulation.
Okay. All right, we're back on the record. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Judge.
According to the plea, you're to plead to counts 1 and count 4. Punishment is to be assessed at 12 years in the prison. There are no applications. And if you are not present for sentencing, you're subject to the full range of punishment. Did you understand? That would mean that if you do not appear, then your plea would stand and the court could sentence you to the full 20 years. And that would still be a part of your plea bargain agreement. Did you understand?
Yes.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Judge, the only thing I didn't hear you mention was the affirmative finding of a deadly weapon.
Yes, there's an affirmative finding of deadly weapon. Did you understand?
Yes, Judge.
Defense?
Yes.
Did you review the paragraph entitled waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Judge.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
No, Your Honor.
Then to count 1, how do you plead? Guilty, not guilty, or no contest?
No comment.
Count 4, how do you plead? Guilty, not guilty, or no contest?
No comment.
State any evidence.
State offer states exhibit 1 and all attachments.
No objection, Your Honor.
Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Judge.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront Any witnesses the state would call and the right to remain silent.
Yes, Judge.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will find you guilty in count 1. Court will find you guilty in count 2. I'm sorry, count 4. And the court will find there is an there is an affirmative finding of deadly weapon. And you are requesting that sentencing be at a different date, counsel?
Yes, Judge. What I'd like to point out to the court, even though it looks like this is a really old case, it just got indicted this year, 2024. We had a plea deadline very recently. We finally got a plea offer. We reached a resolution fairly quickly for a case of this nature. And I'm telling you all that so that you would understand my client didn't have a whole lot of time to start getting his affairs in order. He totally understands the admonishments in the plea agreement. He's single. He needs to dispose of his assets. He needs to leave property with his family. He's been self-employed for many years, and so he's closing down the business. So there's a lot of things that have to be done. We're asking for a date in July, Judge.
All right, I'll give you July 27th. We'll see where we are at that point in time.
Perfect.
All right, is there anything else from either side?
Very well.
All right, once you sign the reset form, you are excused.